In the late 90s, they specialized the parts. So you started having some judges only did delinquency cases and some judges only did Article 10, which are the abuse and neglect cases. And I was part of one of the first in Manhattan delinquency teams where you primarily had juvenile delinquents. And those cases were a lot of fun to try because in criminal law and even in juvenile delinquency cases, the burden of proof is really high, right? It's proof beyond a reasonable doubt. Whereas in other cases, it's sort of more likely than not. So when you had to have real proof, that's fun, right? And if you're a litigator, it's fun. And when you have to know the rules of evidence, and it's just a much higher standard. So, and then when you most of the time lost your case and the judge said your kid's guilty, you then have a dispositional hearing, and the standard is coming up with the least restrictive alternative for that child. So it became almost like the equivalent of the kinds of hearings that you have at the end of abuse and neglect cases when you're looking for resources for your client. So when I would pick up one of these delinquency cases, in the very beginning, you immediately, on the one hand, you're looking at what's the story with the case and was it an illegal search or what was happening, but you also are saying, assuming I lose, what services do I need to have in place so that I can keep my client home with his family?